Advocate Hitinder Shah welcome you to his YouTube channel. I am discussing the topic of arrest of persons under the Criminal Procedure Code. So far, I have delivered the video lectures on this topic in 7 parts, and this is the 8th part of this topic, arrest of persons. Today I will discuss the section 57 of the Criminal Procedure Code. Section 57, it says, heading of section 57 of the Criminal Procedure Code, person arrested not to be detained for more than 24 hours. It says, any such person who has been arrested without the warrant cannot be detained in the custody by a police officer for any such longer period than which is reasonable under the circumstances of that particular case. Any such person who has been arrested cannot be detained in the custody by a police officer for any such longer period than which is reasonable under the circumstances of that particular case. And in the absence of any special order under section 167 by the magistrate, such period of detention cannot exceed the period of 24 hours. So in the absence of any order by the magistrate under section 167, such period of detention cannot exceed the period of 24 hours. Here, this period of 24 hours is the exclusive of such period which is necessary for the journey from the place of arrest to the court of magistrate. However, if the investigation cannot be completed within such period of 24 hours, then officer in charge of police station has to transmit a copy of the entries in the case diary relating to investigation and also to forward the accused person to the nearest judicial magistrate. If the investigation cannot be completed within such period of 24 hours, then officer in charge of police station has to forward the accused person to the nearest judicial magistrate. Then, if such magistrate thinks fit, then he may from time to time, that is for few days at a time, for example 3 days or 4 days, if such magistrate thinks fit, then he may from time to time, that is for few days at a time, authorize further detention of such accused person in the custody of police. However, subject to condition that the whole period of such police custody cannot exceed the 15 days. So, if such magistrate thinks fit, then he may from time to time, for a few days at a time, for example 3 days, authorize further detention of such accused person in the custody of police. But the whole period of such police custody cannot exceed the 15 days. So this is the very important provision of section 57 under the Criminal Procedure Code. I will discuss this topic with the help of one case law. This case law is the judgment of Bombay High Court. It is, the citation of this case law is Criminal Law Journal, year 2018, page 1702. The judgment is given by the single justice, and this judgment is given in the criminal revision application before the Honorable High Court. Criminal revision application. Who is the applicant before the Honorable High Court? Applicant is Parshuram Bajirao Dongre versus State of Maharashtra. Parshuram Bajirao Dongre versus State of Maharashtra. What is this case? In this case, this present revision application before this Honorable Bombay High Court is against the judgment passed by Additional Session Judge Gadchiroli in criminal revision. So, this present revision before the High Court is against the order passed by Additional Session Judge in criminal revision. By the impugned judgment, the revisional court, that is Additional Session Judge of Gadchiroli, the revisional court allowed the revision filed on behalf of the state of Maharashtra. And the revisional court set aside the order passed by the learned magistrate, judicial magistrate, and granted police custody remand, PCR, granted police custody remand of the applicant for 5 days to investigating officer. So, when this applicant was brought before the learned judicial magistrate, he refused to grant extension of police custody remand. Therefore, state has made revision application before the session judge. Session judge allowed the revision application and granted the police custody remand of that applicant for the 5 days, against which this present revision is filed by the applicant before this Honorable Bombay High Court. What are the facts of this case is, FIR was lodged against this applicant before in this revision application before Bombay High Court, that is Parshuram Bajirao Dongre. So he is accused person. Applicant is accused person. According to FIR, since last 4 or 5 years, this applicant accused person collects extortion money from the Tendupatta contractors, big shop owners, builders, etc. Extortion money. That money is extorted for Naxalites. That money is extorted by this applicant accused person for Naxalite, and thereafter he hands over such extorted money to the Naxalites. Initially, this applicant accused person was charged under few sections of Indian Penal Code. But after custodial interrogation of that applicant accused person, it was found by the investigating officer that applicant is also guilty of committing the offence under various sections of the Unlawful Activities Prevention Act 1967. So this is some sort of serious offence, a serious accusation made against this applicant accused person. Then it is also found that it is also noticed by the bank and the income tax department that an amount of rupees 1 crore 20 lakhs were found to be deposited in the account of this applicant accused person. Amount of rupees 1 crore 20 lakh were found to be deposited in the bank account of the applicant, and when the income tax department inquired into the same, nothing satisfactory was found in favor of the applicant. Means from where rupees 1 crore 20 lakhs came to his bank account, nothing satisfactory was found in favor of this applicant accused person. Therefore, according to this FIR, the applicant was arrested on 23rd July 2017 at about 10:30 in night. Applicant was arrested on 23rd July. Then the applicant was produced before the learned judicial magistrate at Aheri, district Gadchiroli on next day, that is on 24th July 2017. At the time of his production before the learned magistrate, the investigating officer prayed for grant of police custody remand of that applicant accused person. The learned magistrate passed the order on the said day, thereby remanding the applicant accused person to the PCR until 28th July 2017. So, first police custody remand was granted for about 24, 25, 26, 27, 28 for 4 days. First PCR. Then on 28th July 2017, that earlier PCR was to expire, hence the applicant was again produced before the learned magistrate with a renewed prayer for extension of the PCR. Extension of PCR. The learned magistrate passed order on 20th July 2017 and extended PCR of the applicant till 31st July 2017. So this is the second occasion for granting of PCR, and PCR is granted in this second situation for about 28, 29, 30, 31, 3 days, for 3 days. So initial police custody remand granted for 4 days, then on second occasion it was granted for 3 days until 31st July 2017. Then again on 31st July 2017, when the applicant was produced before the learned magistrate and when there was a fresh prayer from the investigating officer for granting further police custody remand, then the learned magistrate by order disallowed the prayer made by the investigating officer and took the applicant accused in magisterial custody remand, MCR. So that means on the third occasion, when that applicant accused person was produced before the magistrate and investigating officer prayed for extension of police custody remand, then the magistrate on the third occasion refused to allow this prayer, and instead that applicant accused person was remanded to magisterial custody. So because of this order by the learned magistrate disallowing the prayer for extension of PCR, being agreed by this order, the state of Maharashtra immediately moved before the learned revisional court by filing criminal revision. So against this order of magistrate disallowing the prayer for extension of PCR, state has made a criminal revision application before the session court. This learned revisional court, that is session court, allowed the revision and granted police custody remand for 5 days. So this learned session court granted this revision and granted police custody remand of this applicant accused person for further 5 days, against which agreed by this order of additional session judge, that is revisional court, Agreed by this order, this present criminal revision application has been filed by this applicant before this Honorable High Court. So this is the present revision application. According to the learned counsel for the applicant accused person, the order passed in revision by the session court. The order passed in revision is unjust in as much as the learned revisional court has exceeded its jurisdiction and has substituted its own view in place of the view of the learned magistrate. So this is the ground for challenge. That learned counsel for the applicant submitted that the grounds those were put forth before the learned magistrate on 31st July 2017 for obtaining PCR are nothing but the repetition of the reasons on which the investigating officer was successful in obtaining the police custody remand till 31st July 2017 by remand application dated 28th July 2017. So it was the contention by this learned counsel for the applicant that the reasons which has been mentioned on the third occasion, that is on the 31st July, for obtaining police custody remand, it was the repetition of those reasons for which the police custody remand was prayed for. So nothing new is there. That learned counsel for the applicant also submitted. The applicant was not produced, applicant accused person was not produced before the learned revisional court, that is session court, while granting police custody remand. And therefore, there is a breach of mandate of section 167 of the Code of Criminal Procedure. So, this is another ground for challenge, that ultimately who has granted the police custody remand? It is a revisional court, that is session court. Session court granted PCR for 5 days, but it was the contention of the learned counsel for the applicant that this applicant was not produced before the learned revisional court. Per contra, it is the submission on behalf of the learned public prosecutor on behalf of the state public prosecutor that learned revisional court has correctly stepped in as much as the learned revisional court noticed that the order passed by the learned magistrate refusing the police custody remand cannot stand to the scrutiny of the law, since the learned magistrate failed to consider the ground for which police custody remand was demanded. So in reply, on behalf of the public prosecutor, he said that he contended that the revisional court, that is session court, has correctly stepped in as much as the revisional court noticed that the order passed by the learned magistrate refusing the police custody remand cannot stand to scrutiny of law, because learned magistrate failed to consider the grounds for which police custody remand was demanded. The magistrate has not considered the ground when the application for extension of PCR was made on the third occasion. It is also submission of the learned public prosecutor that the offence is serious in nature and therefore the investigating officer has to be given ample opportunity to investigate into the matter. So this is the reply by the public prosecutor. So the submission of the learned counsel for the applicant accused person that the applicant was not produced before the revisional court, that is session court. Therefore, this Honorable Justice of Bombay High Court observes that in my view that submission of the learned counsel for the applicant, that applicant was not produced before the learned revisional court, in my view hardly require any deliberation. Why? Because the applicant was produced before the learned magistrate on 31st July 2017. That is the third occasion. The applicant accused person was produced before the magistrate on 31st July 2017 at the time for extension of police custody remand. The said was rejected. Said prayer was rejected, and on the very same day, applicant accused person was taken into magisterial custody (MCR) and was sent to the jail. So, it is observation by the single justice of this Honorable Bombay High Court that when on the third occasion, when that accused person applicant was produced before the magistrate on the 31st July, and when the investigation officer prayed for extension of PCR, the magistrate rejected that application of the investigation officer, and therefore applicant was taken into magisterial custody remand and was sent to jail. Therefore, no question arises of producing this applicant accused person before the revisional court, that is session court, because that applicant accused person was not in the custody of police. He was already in the magisterial custody and he was in the jail. Therefore, there is no question of producing by police of this applicant before the revisional court, that is session court. Therefore, it was the observation by the Honorable Justice of this Bombay High Court that, in my view, the revisional court has not exceeded its jurisdiction, in setting aside the order passed by the learned magistrate. Therefore, this present criminal revision application before this Bombay High Court, it is dismissed by the order of the Honorable Bombay High Court. It is dismissed, and the judgment and order passed by the additional session judge Gadchiroli, that is earlier revisional court, that judgment and order passed by the additional session judge Gadchiroli in criminal revision stands confirm. So, on this background, of the facts, in this judgment, the Honorable Bombay High Court has discussed the scope of Section 57 of the Criminal Procedure Code. Section 57 of the Criminal Procedure Code, relating to production of arrested person before magistrate within 24 hours of arrest. So, the wording of the Honorable Bombay Justice, wording of the Honorable Justice of this Bombay High Court, I read the observation in the same wording, and it is more clear. So, Section 57 of the Criminal Procedure Code mandates that person arrested should not be detained for more than 24 hours. Person arrested should not be detained by the arresting police for more than 24 hours. As per the scheme of Criminal Procedure Code, no police officer can detain in custody a person arrested without warrant for longer period in the absence of order of magistrate. So police officer cannot detain a person arrested in the absence of order of magistrate. Thus, before expiry of initial 24 hours, investigating officer is required to produce person detained by him without warrant before the nearest magistrate. So, before expiry of initial 24 hours from the moment of arrest, police officer is required to produce person detained by him without warrant, produce before nearest magistrate. And while calculating this period of 24 hours, period of journey has to be excluded from it. If investigation officer fails to obtain necessary orders from magistrate after expiry of initial 24 hours, then in that event, custody of person so detained by investigating officer shall be illegal detention at the hands of investigating officer. So, if the investigating officer fails to obtain necessary order from magistrate after expiry of initial 24 hours, then in that case, custody of the person so detained by investigating officer shall be illegal detention. In my last lecture, I have explained this point that if the police officer detain the arrested person after the expiry of first 24 hours, then it may amount to offence of wrongful confinement. If investigating officer is unable to complete investigation within the period of those first 24 hours, and if investigation reveals that for further effective investigation, custody of persons arrested is necessary, then it is open for the investigating police officer to approach the magistrate. So, when that accused person is in the custody of police officer, and if the investigation cannot be completed within those period of initial 24 hours, then that police officer has to produce the accused person before the magistrate. At the time of production of persons arrested before magistrate by investigating officer for seeking further detention in police custody remand, it is duty on part of investigating officer to point out to the magistrate grounds for which custody is required. So, before completion of those initial period of 24 hours, if the investigating police officer thinks that the custody of that accused person is necessary for the purpose of further investigation, then he must approach the judicial magistrate and he must pray before the judicial magistrate for the grant of further police custody remand. And he must state the grounds for which further custody is required. And at the same time, it is a duty of the judicial magistrate that he should be satisfied that adequate grounds exist, sufficient grounds exist for granting further police custody remand beyond initial period of 24 hours. If said ground exists, then magistrate can authorize further detention of person so arrested. However, in any case, such detention cannot exceed 15 days in whole. So, in our example, in our facts of this case, when this accused person was first time produced before the judicial magistrate has granted the PCR for the 4 days. On the second occasion, magistrate granted PCR for the further 3 days. but on the third occasion magistrate refused to grant further PCR. So at one time police custody remand can be granted, for example, for 3 days, 4 days, but in total such period of police custody remand should not exceed the period of 15 days. 15 days in a whole. Then after the expiry of such 15 days, that means when that accused person was in the police custody for all this period of 15 days, after the expiry of 15 days, if charge sheet is not filed, charge sheet means police investigation report. After the expiry of 15 days, if charge sheet is not filed, then in that event, magistrate is empowered to take such accused person in judicial custody remand. That is MCR, magisterial custody. That is, after the expiry of 15 days of police custody remand, if charge sheet is not filed, then in that event, magistrate is empowered to take such accused person in judicial custody remand for period of 60 days, 60 or 90 days as the case may be. 60 days or 90 days as the case may be. So that judicial custody remand can be for the period of maximum period of 60 days or 90 days as the case may be. This point is further clear in section 167 of the Criminal Procedure Code. If the final investigation report is not filed by the investigating police officer within 60 or 90 days as the case may be, then accused person is entitled to be released on bail. If investigation report is not filed within 60 days or 90 days of that magisterial custody remand, if final report is not filed within 60 days or 90 days as the case may be, then accused person is entitled to be released on bail, which is commonly known as default bail. So on the ground of when the police investigation officer is not filing charge sheet within the prescribed period of 60 days or 90 days, then in that case accused person is entitled for such default bail. Default means it is a default made by the investigating police officer by not filing the charge sheet within those prescribed time. So this is the provision of section 57 of the Criminal Procedure Code, but it leads to discussion of this topic further, that we need to discuss the section 167 of the Criminal Procedure Code. The heading of this section 167 is procedure when investigation cannot be completed in 24 hours. That is initial 24 hours. Procedure when investigation cannot be completed in 24 hours. So I will discuss this section 167 in my next video lecture. Thank you.